But you made us promise that in no season would your character ever be locked in a cage.
We all remember Savannah.
Another promise was no pet monkey. Chuck has a matching pet monkey with coordinating outfits, and I was like, I would love to be part of the show, but I can't act with a monkey. Then I got a few of them.
She got a few of them.
Come on, it was a joke.
Who else?
Everyone saw the headlines. Almost no one watched the timestamps. When the court trimmed one case and a key name fell off the map, the story didn't end, it changed shape. Blake Lively amended her lawsuit to fix jurisdiction and clean up the record. On paper, that should make a case stronger. In practice, it handed her opponents a faster play. Try to knock out chunks of the case on law, not rumor. That's where it gets interesting, because the fight moved from splashy accusations to quiet rules, deadlines, exhaustion requirements, and whether New York can even touch a Texas publicist. Meanwhile, subpoenas hit creators, and the internet called it intimidation. But in court, speech battles are measured in elements and burdens, not trending audio. If you've wondered why one filing feels like a bomb and another like a whisper, this is why. Not every bomb is allowed into the evidence room, and if your best proof of jurisdiction is that someone read an Instagram caption, the judge might have questions. So today we're following the receipts, the rulings, and the parts of this drama that actually change outcomes. One dismissal reshaped a strategy. One amendment may have opened the door to targeted motions to dismiss. And one set of messages about control reframed motive without deciding anything. Watch the calendar. The timing tells you more than the tweets. But the first crack didn't appear this week. It started the moment the court drew a hard line and forced everyone to play by it. The fastest way to understand this saga is to start with what the court already tossed. In June, a federal judge in New York dismissed Justin Baldoni and Wayfair's huge countersuits. Hundreds of millions in defamation and related claims, finding the law didn't support them. The New York Times claims went out too. A few narrow contract-type issues were given permission to be repled, but the message was clear. The sprawling, everything in the kitchen sink approach wasn't going to fly. That shrank leverage on one side and sharpened focus on what remains. Why does that matter for Lively's case? Because when the court prunes big claims, everyone reads the tea leaves. It tells you which arguments sound loud online, but go quiet under rules of evidence and privilege. It also tells you timing. A trimmed map often means fewer detours and a tighter path to trial. And sure enough, coverage around this time started pointing to depositions and a 2026 trial horizon, not just social media volleys. Here's where it tilts. If one side loses giant counterclaims, they hunt for wins on law exhaustion, timeliness, jurisdiction. That's not PR, that's chess. Then came the jurisdiction domino. Lively's claims against Texas-based publicist Jed Wallace and his company, Street Relations, were dismissed for lack of personal jurisdiction in New York. Translation, the court said it didn't have the power to keep him in this case there. Whether you love or hate that result, it matters because it's a template. Other out-of-state PR figures can now point to that ruling and say, "Same logic, Your Honor." That's a strategic shift. The judge has been running a tight ship on briefing. At one point, he even limited pages for a Wallace-related response to 2 single-spaced pages. That's not gossip, it's management. Short, focused arguments, no kitchen sink. It signals that new attempts to rope distant players into New York need surgical precision, not vibes. And this is why the second amended complaint became high risk, high reward. Amendments can fix holes. They can also give every defendant a fresh chance to attack weak spots fast. Blake Lively filed a lengthy amended complaint, hundreds of pages, exhibits and all. Once you do that, it supersedes the old pleading. Defendants don't have to answer the old one anymore. They get to decide, do we answer this new one, or move to dismiss specific claims now? If you believe certain counts are time-barred, unexhausted, or still jurisdictionally defective, a motion to dismiss is a scalpel you can use today instead of waiting months for summary judgment. That's not a technicality, that's law. And yes, to clear a common confusion, this is Wayfarer Studios, the film production company, not the furniture retailer Wayfair. It matters. Names get repeated online, and then morph into something else. Court captions and PDFs don't lie. When you read the amended complaint, you'll see allegations threaded through chronology, on-set incidents, later press cycles, PR linkages, and statements Lively says harmed her. Some claims hinge on employment rights and anti-retaliation theories, others hit defamation. All allegations are just that, allegations until proven. But procedurally, the amended filing handed each defendant a menu. Pick your motion, pick your timing, and if you think exhaustion rules or statutes of limitation block certain counts, you file now. The judge decides, not the algorithm. And that brings us to optics, the other trial happening in public. Because while filings moved chess pieces, the headlines moved something else. Attention. Creators started receiving subpoenas, Some balked, sought protective orders, or accused Lively's side of overreach. Others framed the whole discovery push as a necessary part of fact-finding. The optics were brutal. Anytime a celebrity's legal team pulls creators into a federal fight, the internet treats it as a gag order, even when courts view it as standard process. That gap between optics and procedure fuels watch time and outrage, but it doesn't necessarily move a judge. Still, it adds pressure, because non-party fights can snowball into stories of intimidation or speech suppression. One creator's filing landed with a thud online. A request for a protective order, couched as a defense of free expression. Whether a judge agrees or not, these moments feed the content engine. Discovery becomes content. Content becomes discovery. It's a feedback loop. But the parts that matter most to the case are still the legal elements. What must be proven, who said what, where, and whether the forum is correct. That's not glamorous, it's decisive. And yet, the loudest blast wasn't an affidavit or a tweet. It was a quiet set of messages. The kind that look mundane until you ask what they imply. Control. There's an unresolved tug-of-war at the center of this story. Was creative control a necessary byproduct of safety concerns, or the goal all along? Coverage and filings point to a dense mix of edits, approvals, and notes that, depending on who's telling it, either protected boundaries or tightened grip. If you're looking for a pure gotcha, you won't find it. What you will find is timing. When certain agreements were negotiated, what scenes and marketing beats were at issue, and who had final say when it mattered. That's where narratives about motive find oxygen, even when proof of wrongdoing remains contested. This is also why a 2018-era message thread about edits, approvals, and Blake's call ricocheted through commentary. To one side, it shows a star asserting boundaries. To the other, it reads like leverage for creative control that later shaped the cut. Courts care less about vibes and more about contract language, authority, and whether any statement about it was false and made with the required level of fault. That's the ground where defamation lives or dies. And we've already seen how judges handled sweeping defamation claims on the other side. They tossed them. Except one detail refuses to line up in the public mind: jurisdiction. Because if your theory is that watching someone's Instagram proves you aimed at New York, you're going to meet the word no, which is exactly what happened to Wallace. The court didn't say he's right or wrong about facts. It said New York wasn't the place to decide it. That's a boundary with consequences. If you want a clean signal through the noise, watch dates. June brought the defamation dismissal against Baldoni/Wayfarer. Mid-July brought the Wallace jurisdiction dismissal. Late July and early August brought scheduling moves and deposition chatter, including reports that Lively's deposition timing shifted by a couple of weeks as counsel conferred and reset. These aren't fireworks, they're mile markers. They tell you we're past the PR boom and into the roads that end in motions and trials. The map is tightening, and timing matters for something else: strategy. If defense believes certain employment-related counts are time-barred or not properly exhausted with the right agency, those arguments get sharper as months pass. If plaintiffs believe they've shored jurisdiction and clarified who did what, when, and where, they'll push to keep more claims alive into discovery. Motions to dismiss now versus summary judgment later is the fork in the road. One path cuts sooner. The other gambles on a bigger swing after fact development. Both are wins if they remove claims with prejudice. Both are losses if the court says, no, we're going to hear this. But that wasn't the whole story. Because as the calendar tightened, the speech fight didn't stop. It just changed arenas. The court didn't just dismiss Baldoni-Wayfarer's big defamation case. It spelled out legal protections that make some statements off-limits for lawsuits: privilege, newsworthiness, and fault standards that get tougher when the subject is public and the topic is of public concern. That's not a pass. It's the rulebook. The same rulebook will govern how judges look at Lively's defamation-adjacent claims and any counter-narratives about smear campaigns. You can believe something feels unfair and still lose in court if the law says speech wins. That's what a lot of people missed when they celebrated or mourned those dismissals. The court wasn't picking a team, it was applying doctrine. For creators, that matters. It's why some push for protective orders, arguing subpoenas chill speech. It's why others argue discovery is fair game when allegations claim a coordinated campaign. Both things can be true in different circumstances. But online, nuance dies. In court, it decides cases. And if you think that's dry, remember, the speech questions determine what evidence gets in, which claims survive, and how juries hear stories. That's where reputations are actually repaired or not. She amended the lawsuit to make it stronger, and may have given her opponents a quicker exit ramp for certain claims. One dismissal showed how hard it is to rope distant players into a New York court. One management order showed how little patience the judge has for sprawling arguments. And one set of messages about edits and approvals will keep feeding the internet no matter what the court decides. If you strip out the noise, 2 levers move this story: jurisdiction and timing. They don't trend, they decide cases. So here's the thought to take with you. When a court trims a lawsuit on law, does the narrative actually change, or does it just move platforms? Because if the silence breaks, we'll find out which version holds up, the one that wins comments, or the one that survives the gate.